Please welcome Jane Meadus.
To this annual general meeting to make a presentation that I think is extremely vital to all of us, whether we have elders in our family or whether we're elders ourselves. And definitely if we have elderly clients out in the community, we all need to know the information that Jane's going to provide us. And she always does so with such style. And I'm very much looking forward to hearing her speak. Over to you, Jane.
Thank you very much, Shelley. I'm glad to see everyone here today. And a couple of people that I would personally like to acknowledge. First of all, my parents are out there somewhere. So hi, Mom and Dad. It's nice to, it's one thing that's nice when you're on Zoom. Your parents can attend remotely. And I would also like to say hi to Diane and Francis, who I'm so pleased are here today and have gotten online. Hi, ladies. So we'll see you again sometime soon. And Diane and Francis have, I think, come to pretty much every single ACE AGM that I can remember. So it's lovely to see you again, ladies. So thank you very much. I'm going to talk a little bit about Bill 7, and most of you probably have received the newsletter that had that as an insert. And of course, the reason it was an insert was because we couldn't know from day to day what was happening. And the government, brought this out very quickly. So I'm going to start actually a little bit before that. So I'm just going to sort of talk about what the history of the legislation was up until the summer. So as many people will recall, we had the Long-Term Care Homes Act, and that was brought in 2010. And that legislation was a very comprehensive legislation, governed long-term care. It was probably one of the most comprehensive pieces of legislation about long-term care, in the world, actually. It was a huge piece of legislation and covered most aspects of long-term care. It certainly wasn't perfect. It had lots of issues, but it was a pretty good start. ACE was, very involved in the creation of that legislation, participating in committees, that actually, we hashed out things that were going to go into the legislation. So it was we were pretty pleased with that piece of legislation. The Conservatives came in and really didn't do much in the way of long-term care, no matter what they say. They really didn't do anything about the long-term care system. They made, a few comments and things around when the Galeese inquiry into the wet law for murders came out, but they weren't doing much of anything. They pulled back on inspections, so they did fewer inspections. They weren't giving licenses or anything like that until COVID hit. And then, of course, once COVID hit, long-term care clearly had this big focus on it, and all of a sudden they realized they had to act, and they started acting very quickly. So in November of last year, they brought out a new piece of legislation called the Fixing Long-Term Care Act. And as with many pieces of legislation that have these kinds of days, it wasn't doing any kind of fixing. There are certainly things in that legislation that are new and that are quite good, but there wasn't anything particularly different. Most of the legislation is simply a continuation of what was previously there. There were some changes. It imported some of the changes that were made during COVID. But there was definitely a change around some of the inspection processes, but again, it only helps if they actually inspect homes. So if they're not actually inspecting homes and they're not doing as much as we'd like, if they're not inspecting, nothing's going to change. And so that came in April of this year, and everything was going along. And then, of course, this summer, we started to get this problem of these, ALC beds. Now, if anybody's been to our AGMs before, you'll have seen me talking about the ALC issue before, and you'll know that we always had problems around things like hospitals trying to have first available bed policies, people being prevented from applying to long-term care, people being told that they were required to go to retirement homes, sell their house and go pay for an expensive retirement home. Families were told, even though they would say, I cannot provide care to my spouse, my parent, whatever, they were told that they were required to do that and they were going to be sent home. And I've actually been been seen numerous cases where people were told that they had to, that the hospital was just going to simply put grandma in an ambulance and send them over to your house and leave them in your driveway, and then you'd have to take care of them. And this is something that, for the 27 years that I've been at ACE, that we work very hard to make changes, make sure that these things weren't happening, trying to get hospitals not to interfere. And in fact, one of the things that happened over the years when I started, hospitals were very much part of the process of admission to long-term care. And, by the end, up until Bill 7, really the hospitals had been taken out of that process. They might refer someone to the long-term, to the HCCSS, which is what the LIN is now called. And they would obviously provide information about the patient to the HCCS. But other than that, they really weren't part of the process. That didn't mean that they didn't try to be part of the process. And as Alyssa can attest to, and Angie and Kimberly and anybody else doing intake at our office, we hear these stories all the time that the hospitals are telling people they can't apply. They're blocking people from actually talking to the LIN, the HCCSS workers, et cetera. So, this is the kind of issue that we've had all the time. And so we've actually taken the placement process away from the hospitals because of the way that what had happened and the manipulation and what had happened. So we start to have this problem in the summer, and mainly, in my opinion, is to do with the lack of staffing for the hospitals, the lack of funding for hospitals. And we started having this huge problem with people backing up in the community or in the emergency rooms, not being able to get services very quickly, not being able to get beds very quickly. And one of the things you should know is that hospitals in Ontario have the least amount of hospital beds per capita in Canada by a long shot. The Ontario Health, the Ontario Health Coalition actually just put some stats out. I just saw those today. And it's really quite stark how much less of those beds that we have. So, that's part of the problem. And the other problem is, we've been changing things from chronic care, have been removed from our system. They make them rehab instead. A lot of people who would have ended up in sort of chronic care are ending up going to long-term care. We have a huge issue of people not getting proper care while they're in hospital. So one of the things that I hear all the time is that it's not the care for the issue they have, it's the other things. So they're not getting out of bed, they're not getting walked around, they're being put into incontinence products. I can tell you from personal experience, when I had back surgery, they tried to put me in incontinence products, believe it or not. You can imagine that I didn't accept them, but it wasn't because I was incontinent. It was because the staff did not want to come in at night and change me. And in fact, they were actually contraindicated because I'd had back surgery and I wasn't supposed to have them, but they really, really pressured me. People aren't getting dressed, they're not getting up and down. So there are issues in hospitals, and there was actually a really good article that was done it was in the Toronto Star on and I just want to look at the date, September the 29th, by Jenny Bassran and Andrea Grunier and George Heckman, that talked about part of the problem being that the senior-friendly hospital measures have shown to prevent delirium in hospitals, falls, functional decline, long-term care admission, and to lower healthcare costs, yet only a handful of hospitals across Canada have implemented these. We hear a lot about hospitals, having to be senior friendly, yet hospitals if you look at the percentage of the people in hospitals, most of the people in hospitals, a large percentage are seniors, and why we actually have to make an effort to make them senior friendly. They should be senior friendly by design. But what we have happen is that we had this backup, and the government was getting pressure to do something to fix the system. All of a sudden, on August the 18th, Minister of Long-Term Care, Paul Calandra, introduced the Bill 7, the More Beds, Better Care Act 2022, better known at the time as Bill 7, which was an amendment to the legislation that they had just passed in the spring. This was entirely unexpected. As you may recall, we had just had an election, and this had never been anything in the election. No one had ever spoken about this or doing this kind of a process. And this really was, putting the system that we had for placement on its head. Despite the name, it doesn't create any new beds, doesn't provide better care. What it does is it's giving a mandatory first available bed requirement into the process for people who are in hospital beds, to allow them to be pushed out of the hospital for what is seen as more deserving patients. We continued to see over time that they kept saying that, we needed to get them in because they weren't acute care anymore. Well, they may have not have been acute care, but they may have been something else. Another thing that they never talked about during Bill 7 was the fact that while we do have about 6,000 people who are alternative level of care in hospital, and alternative level of care means that you're finished whatever stage you're in of the hospital, you need to go elsewhere, but for procedural or systemic reasons, you can't move on. So there's no beds, for example, in a long-term care home. That of those 6,000, only about 1/3 of those are destined for long-term care. Many of those are destined, for example, for rehab beds, for other kinds of care within the system. But we don't hear about that. We didn't hear any solutions for that either. We just kept hearing that we had to clear out the hospitals of these ALC patients who were going to long-term care. It was very clear from the beginning that, the system, even people like Advantage Ontario, who are the umbrella organization for some of the nonprofit homes, said, their comment from Lisa Levin, their CEO, was, we cannot help one part of the health sector by putting more pressure on another part, especially one that's already in crisis. And the fact that the hospitals were in crisis because they didn't have enough nursing staff and other kinds of staff is one thing. The long-term care homes have just as bad or even worse a problem, because one of the reasons we're seeing, people are quitting, people are retiring. It's a hard job in both hospital and long-term care. I'd submit that in many cases, long-term care is harder for our nurses. They're the top of the food chain. They have to kind of run the homes. They're responsible for everything pretty much. And everybody's wages are low, but the nurses in long-term care generally are paid less than hospital workers. So if hospitals can't find somebody to work, they're not going to long-term care. They also began to have the same problems as the hospitals, having to use agency staff. So we had a really big problem with respect to the system was collapsing, or is collapsing. And we really didn't have, this really wasn't, in our opinion, a solution. However, the government quickly passed the bill and made it into law. They passed time allocation motions, which allowed it to move very quickly from second to third reading. And they refused to refer it to committee for public consultation. Generally, legislation, especially something like this, would be referred to a committee so that you could make you could make submissions. So ACE would have made written submissions and very likely also oral submissions, but they did not do that. And then the bill passed on August the 31st. So from August the 18th was the first thing we ever heard about it. August 31st, it was passed into law. Now, that didn't mean that they could actually use it yet, because they didn't have any regulations. And we were told, and Minister Calandra kept saying, those regulations would be released the following week. No regulations came, and we waited and we waited and didn't know what was happening. There was no news. I was trying to find out what was happening. Nobody seemed to have any news. On September 14th at 3 p.m., following the adjournment of the House at 2:47 p.m. that afternoon, so 13 minutes after the House rose for a 5-week break, must be nice, Minister Calandra and Minister of Health, Sylvia Jones, held a press conference announcing the regulations. They announced this, they set out when the ALC patients would have to go to long-term care homes that were not of their choosing, and that if patients did not agree with their hospital's discharge plans to the community, they also would suffer consequences. And this was something that had never been discussed before. It had not been anything part of what was going on in the hospital. We knew that there was going to be we knew that they were taking away the rights of people to consent, but we didn't know what was going to happen. And what they did was they made changes to the Public Hospitals Act regulations that said hospitals would be required to charge a daily fee of $400 to all people who had been discharged by their doctor with a care plan that delivers more appropriate care, and that's in the assessment of the physician, such as to long-term care or home care or perhaps something else, but they choose to remain in the hospital. So that means that if your doctor says, I think you should go live in a retirement home, and you don't go and leave the hospital, that they theoretically, according to this, they can start to charge you $400. Again, this was filed without consultation. It came into force the following week. The $400 copayment portion of that doesn't come into effect until November the 20th. So until November the 20th, the hospital still can charge, but it is not regulated. So they can charge anything they want. So they could charge patients $1,800 a day, like we were talking about before, in which we have actually seen people charge $1,500, $1,600 a day for not leaving the hospital when the hospital says that they shouldn't be there anymore. And in the cases that we've dealt with, where people have been told to go somewhere else and where these charges have happened, have been really egregious cases. And I'll give you an example. We had a client who had been brought to the hospital under the Mental Health Act, had to be restrained continuously in the hospital. When they were fed, they had to be restrained. They had actually gotten quite poor care while in hospital. And the family really had to advocate for them to actually get some necessary surgery that they needed, because they were seen as a difficult patient that the hospital had not pursued. But eventually, an application for long-term care was started. And as you can imagine, they were turned down by every home. No home would accept them. And the hospital said, well, no one will accept you, so you must take them home. And it was an elderly spouse at the home who was supposed to care for them. And they started to charge $1,500 a day to that senior because they didn't leave the hospital to go home to be cared for by an elderly spouse in a situation where they were quite dangerous. And the reason the long-term care wouldn't accept them was because they were way more than they could provide care for. So we're not talking about cases here where people are, only picking the home that has the 5-year, 10-year waiting list. This is not generally what we're talking about. We really are talking about people who are trying to make the right choices, trying to do the best for themselves or for their family members or the people that are making those decisions for, and who are not being allowed to do so. So what Bill 7 is doing is saying that no longer does the HCCSS have to actually get consent from anyone if they don't believe that a person is being reasonable, and whatever that means. They can and will make an application, choose the homes, send the applications to the home without your consent, including all your personal information. That home can determine eligibility. A bed can be offered. And if you're offered the bed, you have a choice. You can go to the home. You can not go to the home and stay in the hospital, at which time they will start to charge you $400 a day. Or you could leave the hospital and go elsewhere. And this is absolutely in contravention of all of the rules that we've had with respect to consent and capacity. They've decided to override the consent of the elderly, or vulnerable persons, because of course this is for anyone who's 18 years of age and older, this long-term care. And so we're actually seeing quite a few more people who are younger going into long-term care. because we don't have enough assisted living, we don't have enough home care in the community, and they want to free up beds. And I know of a few cases where I'm really expecting people who hospitals have very much been trying to get rid of out of, say, chronic care for a long time, where people really aren't appropriate for long-term care, and they are going to say, well, we've decided you can go. One of the things that you need to know about long-term care is that the legislation does not include any upper limit for care. So there's nothing in there that says if you need more than 5 hours or if you need certain kinds of equipment, that the home is not acceptable to you. So if we have homes that are trying to fill their beds, homes that have empty beds, and if a home isn't at 97% occupancy as of October this year, again, they've gone back to the old system where if they're not at 97% capacity, they're not going to get 100% of their funding. So those homes are going to say, well, we need somebody in these beds or we're not going to get our money. And those people are going to get accepted. And those are often the homes that are, having the most problems, that are least able to provide the care to the people who need those beds. And I think what we're going to see through Bill 7 and through this new legislation is people who have high care needs, who have difficult care needs, but don't have really good advocates. Those are the people who they're going to choose to take and send them to these beds. I think that, obviously the issue around consent, this has been sort of a cornerstone of our legislation, is that we all know that you need consent to treatment. And we've actually legislated the consent for placement as well. We often will hear from the government saying, well, not others do this. And I don't disagree. I think there are places that aren't doing it. I've spoken to other provinces and they've told me, oh, well, we just, take grandma and throw her in the car and send her to the home that we want her to go to. Just because somebody else is doing it wrong doesn't mean that we should as well. Consent is very important. Where you live, this is going to be where the person is going to live for the rest of their life. We also have a government that says, as part of the process, is saying what they tell the HCCSS as part of the process is that in order to help the people make their decisions so that you don't have to do this, without consent process, one of the things that they're telling people is that you need to tell them how to find information about that home on the Ministry of Health website. So if you go to the Ministry of Health website, as you're told, and find out that the home that they're suggesting is substandard, has, a lot of inappropriate, has a lot of compliance orders, has a bad history, maybe it did very poorly during COVID, and you come back and you say, oh, well, we can't go there. They can override that and say, well, that's nice. I'm glad you find out that information, but we're going to try to send you there anyway. So what the legislation basically does is says you have two options. You can, go through and do the process and make your decisions properly. But if we don't like what you're doing, we're just going to make you do what we want anyway. And we don't know what reasonable means. We don't know how they're going to figure that out. We, I think, are going to see a lot of people who are, like I said, are on the margins, who don't have advocates, don't have family to speak up for them. People where there are substitute decision makers who really don't know the process, don't know what the rules are. They're going to have heard of this. And of course, anybody being told that you're going to be charged $400 a day is going to be quite terrified of what is going to happen, in that situation. And most people can't afford $400 a day. It might as well be $1,500. It doesn't really matter. If you're on low income, it probably doesn't matter at all. Now, one of the things in our that we've said is that for people to remember that if the hospital does go through the process and you do turn down a bed, perhaps it's in a home that, where the military had to take over during COVID, and that's the home that's being offered to you, and you say no, If you are the patient, then the hospital will be able to bill you. If you are the substitute decision maker, the bill is going to go to the patient. Now, are they going to be able to uphold that, for example, in court? Would the court say that because your substitute decision maker refused to do something, that you as an incapable person can be charged? I'm not sure whether they would be able to, whether they would support that or not. But many people who are in hospital, seniors, are low income. And it may be that the hospital couldn't collect from them, even if they did charge them the money. So people who are in hospital need to get legal advice if they are refusing to move, because you have to look at whether or not that person has any income that they can get, because things like CPP, OAS, and GAS are not garnishable. So the hospitals may actually not even be able to collect that money. They can charge as much as they want, but they probably can't collect. And really the only way to collect would be to sue you and then win, and then, have a way of collecting. If you're only on those kinds of pensions, they cannot collect. Now, if you have a home, they could get a lien on your home potentially, or if you have some other assets or other kinds of income. So if you think you're going to be getting charged, you may want to look into, that situation and see what's going on. But the government has set it up so that the hospitals are required to do things, but they're also leaving it in the hands of the hospitals to do all the collection and all the dirty work. And so we will see what actually happens. One of the interesting things is that with respect to patients going into from hospital as an ALC patient into a long-term care home, is that it's probably only going to free up about 250 beds to begin with. It's unclear. They're opening up things like short-term beds for respite. They're reopening some convalescent beds. So some homes will, any beds that they may gain because they're getting rid of the isolation beds in homes. So those beds will be opening up, and those may free up some home beds for people from hospital, but the rest of them, they may be actually getting used in a different way anyway. So it's really unclear as to how helpful this system is going to be anyway. Another promise that the government has made is that they have indicated that they are going to put in a number of different kinds of programs that to help people. And those programs are the new Local Priorities Fund, which, as far as I know, hasn't been established. So that would be to assist with equipment, such as bariatric equipment, maybe changing door frames in older homes. They're going to have some sort of services to support placements in particular local contexts. We don't know what that is. Virtual behavioral medicine out of Baycrest. Don't know if the program's set up, and I'm not sure how helpful that is. We certainly do have Behavioral Supports Ontario, which will continue for that. The High Intensity Needs Funds. Now that's a fund where you can get someone have like a one-to-one. You might get someone who will move into a private room who can get a sitter paid for them, or have the private room paid for them, I should say. But you can't actually apply to those or even know whether you're eligible until you actually move into the home. So I don't know how this helps this program, because no home is going to want to accept someone who may be turned down on one of these programs. Another very interesting thing that I thought in this legislation and the regulations was a very big emphasis on Developmental Services Ontario and wraparound programming from them. And what really disturbed me about that was this really is signaling to me that there are a lot more people going to be coming into long-term care from the developmental services area. We have seen some already. I've certainly had clients, and you go into homes and you definitely see people who come with, have some kind of developmental disability. But it seems to me that the government has thrown up their hands and is not going to be supplying or providing housing that's appropriate to that sector. Instead, they are going to be putting them into long-term care. Can people with developmental disabilities be dealt with in long-term care? Sure. Part of the problem with long-term care, though, is that we throw everybody in the mix. It's 18 and over, doesn't matter what your disability is. So If we had people who were properly trained in dealing with people with disability, developmental disabilities, and had, a special home for people who are older, who have maybe dementia, because people with developmental disabilities of certain types do get dementia earlier, that might be appropriate. But that's not the system that we have. And really what it's telling me is that they have people that they're aware of who they are trying to get out of hospital into long-term care, not because it's good for the person, because it's good for the system. And it is really, I think, going to be quite problematic. Another problem that they haven't resolved, for example, is the issue of some of these applicants. So many of these people who are stuck in hospital, and one of the things you'll have heard if you listen to the media is discussion of how some people were in the hospital, have been in the hospital 6 months, a year, 2 years, what have you. And again, those generally, and I'm not saying that it never happens, but generally those are not people who are waiting for that home that has the 11-year waiting list. Generally, those people who we call who are eligible but unplaceable. So a person has been determined to be eligible by the HCCSS, but no one will accept them. And this legislation talks about how the homes, really have to accept people if the application goes to them. But part of the problem is that we have a system where there's only 2 reasons why a person can be refused long-term care. And that is, as long as they meet the other criteria. So you have to be 18 and have an OHIP card and things like that. But there's only 2 specific reasons that the home can, after they've gone through the eligibility through the HCCSS, is that they don't have the nursing expertise or be able to get it, or that the physical facilities they can't meet the person's needs. Usually what we see is things around nursing expertise. And we very often see these more difficult clients. If they apply to homes that have long waiting lists, homes that are the more desirable homes, they are often turned down. And those homes, frankly, often cherry pick their clients and don't accept these people. And when we look at if we get to see the letters, what we find is that there's no real reason that those people are not being accepted. But what this ends up happening is that the homes that can least provide that care, the homes that are struggling, often end up with those clients in order just to fill their beds. And I think this is going to happen here. I don't see Bill 7 helping people getting into homes that they want. I see them getting into homes that they don't want. Another issue that I think is really disturbing is the fact that, as you may be aware, the Bill 7, if you were being placed by the HCCSS coordinator and you're not making your own choice, it's, I believe, 70 kilometers, 70 kilometers from your preferred location if you're in the south. If you're in Northeast or Northwest Local Health Integration Network, and yes, it's still called the LIN in the legislation. If you are 150 kilometers from the preferred location, that's as far as they can send you. Unless if you're in the north, there isn't one, and then they can send you farther. So in the south, it does have a 70-kilometer hard stop, but not in the north. It could be farther than 150. It's just the next closest bed. The preferred location is an address identified by the patient or their substitute. And if not, if they don't identify a address, then it's from the hospital that they're in. So you're going to get a home. They're going to choose it for you. You may have chosen many other homes, frankly, and those homes may be refusing you on inappropriate grounds that nobody's following up on. You may be on long waiting lists, and that's not your fault. And yet now you're going to get pushed into some other place because they want the hospital bed, because there hasn't been enough proper planning in our healthcare system. Those people are going to be told, well, again, we're not going to physically move you because that would be an assault. But most people, I think, will probably cave and go. What we're seeing right now, we have not yet seen, and nobody I know, we've asked this at a few meetings, nobody I know has actually seen anybody forced into a home that they haven't chosen. And that's because people are told, well, you better make all these choices. Because if you don't, this is what we're going to do. So people out of fear are already complying and choosing places that they don't want in order to try to get not get into this situation. But presuming they choose someplace and they get to go there. So let's say you're in the north and you're in Kenora and the closest bed is in Thunder Bay. The government has made it extremely clear that you must not only go to the home in Thunder Bay or pay that $400 a day, but you must also pay for the privilege of doing so. So if you're in a hospital in Kenora and you're in bad, you're not in great shape and you can't take the 6-8 hour drive or whatever it is to Thunder Bay, you have to fly. And if you're flying, you have to pay for that. There is no funding for that. There's no funding for your family or anyone to visit you. And one of the things, of course, that we learned during COVID was that people who don't get visits can deteriorate. Visitors are very important in long-term care. It's not only just the person, it's the physical, like the work that people did. I don't think the government knew. We knew, but I don't think the government was really aware how much care was being provided by third parties like family members, friends in long-term care until COVID hit and they kicked them all out. So they're going to lose all of that care, which is usually great assistance to the home, but is very good for the person because the family member is always going to, not always, but is generally going to be know that person better, know their habits, know, the little idiosyncrasies of that person versus, the nurse or the agency person who might be coming in. They're also going to often be able to identify issues, subtle changes that, staff just don't know because they just don't know that person as well. And family members often do that. They're going to lose that. Because they are not going to be able to visit. And there is not going to be any money assisting that person visiting. There's going to be no money to assist that person. And so that if you're sent from Kenora to Thunder Bay, you're going to be moved away from your family in Kenora. If you are, for example, let's say you live at Yonge and Eglinton and you're 85, you don't drive anywhere more, and your husband is moved into Hamilton. Okay, so you are in a walker, you can't do stairs. So you're at Yonge and Eglinton. Yonge and Eglinton is not an accessible subway station. So now you have to get to an accessible subway station. You get on the subway, then you get on the GO train. You take the GO train out to Hamilton. Then you either have to take a taxi or somehow get to Hamilton Transit to visit your spouse, and then you come back. How often are you going to be able to do that? What is the effect going to be on your personal health? That's another issue that no one has looked at. And frankly, what I think this system is going to do is that it is going to actually just have a revolving door. What is happening now is that if you want to get into long-term care, the only way to do it is to do it from hospital. They're only placing from crisis right now in the majority of homes. And hospital beds are now all deemed crisis. And crisis is not as of a date on a list. It's as of date, but also as of need. And it's up to the HCCSS to decide who gets that next bed. So if you are in a hospital bed and someone's in the community waiting and their family's taking care of you, that hospital person is going to get the bed sooner. What if you're living in the community by yourself? As long as you're not, you have to be in pretty dire straits to beat somebody in a hospital bed, I'll tell you, for crisis admission. And so what is going to happen is you're going to get caregiver burnout. You're going to get people injured in the community because the family isn't able to properly move or, what have you, like transfer them or what have you. You are going to get caregivers getting injured as well. And so what's going to happen is all those people are going to end up in the hospital. And many of those people who are discharged from the hospital are going to go. And one of the big problems as well that I think that the healthcare system is not really aware of is that the discharge. So they have this, process that says that the doctor can, determine that you're to be discharged if there's an appropriate care plan. And who sets that appropriate care plan? Well, it's up to the doctor to make sure that that person is being safely discharged and appropriately discharged. It's unlikely in a hospital in most cases, not in all, but in many cases, it's unlikely that the doctor themselves are coming up with the care plan. It's probably a social worker, a discharge planner, or somebody like that says, here's a care plan. The doctor says, okay. Doctors generally aren't trained in knowing what's available in the community. They don't know how much home care is available. They don't know what the services are. They may have a general idea, but they probably aren't as hooked in. That's not their job, it's someone else's. But it's their responsibility. And they are going to be personally liable if something happens, if that person is discharged to the community and they, the family says he can't be cared for in the community. We can't do it. It's not possible. It's unsafe. They do it anyway. And that person is injured or dies, they're going to get sued. And I don't think that many physicians are aware of that in this context. So what are the things you can kind of do about this? Well, I think we need to continue to challenge the system. If you're a patient and you are choosing your homes, be able to articulate why those homes are the homes you want and why the homes at the hospitals where the HCCSS wants you to go to are not appropriate, so that you can argue that you are being reasonable, that you actually have a reason to not do that application. Same thing if you're a substitute decision maker. Look at what the requirements are under the Healthcare Consent Act. They have not gotten rid of the requirements of the substitute decision maker. So look at Section 42 of the Healthcare Consent Act. What do you have to consider when you're making a decision for someone else? And be able to say why your decision is reasonable. One of the things that hospitals can do is if they actually thought you were not following the law, if you're not following the Healthcare Consent Act, they can bring a Form G application. And they've chosen not to do that because they know really the government has chosen to not go that route, instead to just try to force the admissions, because they know that if it did go to a board on many of these cases, they would not be able to prove that the substitute was not complying with the law and wasn't making a decision in compliance with the person's best interests, because the homes that they are going to be trying to put people into are probably not in the person's best interest under the law. You can they've put in the legislation that they can release information about you, but they haven't overridden the Personal Health Information Protection Act. So I suggest that you could always tell the HCCSS that you are putting the information into a lockbox and that they may not share it with any home without your consent. If they do so under the legislation, I would bring a complaint to the Information and Privacy Commission that they have not complied with the law. And I think that is a way of challenging this legislation. Again, we talked about the fee they may not be able to collect. And if that's something you're thinking about, you should get legal advice. If they are saying that you can go home with, say, home care, get a require a written agreement with HCCSS as to the amount of home care, what they're going to do if someone doesn't show up, how long that home care is going to be for, because what we often have seen in programs in the past is people going home on very short periods of time. Say they go home for a week on 20 hours a week, and then as soon as they get home, they get reassessed and have it removed, or that the services are only for 30 days. And of course, you're never getting placed in 30 days. So that's a problem. Make sure that you understand you don't have to sell your home. You don't have to go to a retirement home. It's not part of our healthcare system. If alternative type of facilities are being offered, and these would be non-hospital units, it could be a floor, for example, in a retirement home that the hospital says, well, we have an agreement with a certain agency with respect to this facility. And, you can go there and just pay the same as you would be in hospital. And, it's in a retirement home, and, this other organization will provide you with the care. Those probably are not retirement home beds. They're probably funded through by the Ministry of Health through the hospital, but they have no oversight and no rules. And I would be very careful about going into any of those programs. If you have media is always asking us for people to talk. Media is, going to be, I think, part of the solution here. The more stories we can get into the media, if things go wrong, make sure it goes to the media. If you're getting pressure, the media is always wanting to know. And again, contemplate litigation. As Graham indicated, we are looking at some litigation, and some litigation will be on sort of that, higher level of applications under the charter, but there certainly is going to be room for individual litigation as well, in some cases. And, whether it's us or we refer it out, we certainly have, some other lawyers who are very interested in this area of law. That may be something as well. So I think that we're at early days. We can make a lot of suppositions about what's happening. We're certainly hearing from a lot of HCCSS workers on the ground, they don't want to do this. I think that the squeaky wheel is probably going to get the grease. So the more, if it's your family member, the more you push, the more likelihood that you're going to get a bed in a home you want versus going down the no consent route. But I think it's just going to be a lot of pressure and stress on people. And I think people eventually are going to be harmed because they're sent home inappropriately, or they're going to go to a home and have no family. And, their health will deteriorate very rapidly. And so we'll have to see how this all shakes out. But I don't think it's going to fix the problem. In fact, it could end up with more people if you end up with more sick people coming in the hospital because of this sort of revolving door problem. Thank you.
Thank you so much. As always, concise, clear, to the point, and advocating on behalf of the elders who are stuck with this mess.
Sadly not cheery.
No, I know. But it can't be cheery given the circumstances that have been, thrust upon everybody. I understand one question that has been asked is if ACE is going to challenge this, what would they need for ACE to be able to actually bring a court case or challenge it?
That's a Graham question.
Well, send that to Graham then.
He's right there. He can answer it. He's there. He can answer it.
Just because it clearly is legislation that was, pulled out of an opening somewhere as opposed to actually thought out.
Yeah.
We are looking at this legislation and trying to formulate a legal challenge to it. We're working with a number of different groups. One group that we're meeting with is the Ontario Bar Association to see what position the OBA will take with this. We're also meeting with other groups such as Concerned Friends, the Ontario Health Coalition, groups of lawyers that are representing long-term care residents and their families to explore legal theories and to discuss the possibility of what legal action would look like, what form it would take. And we are also meeting with a group of lawyers, retired lawyers and retired judges, all of whom are experts in constitutional law, to give us advice on any court challenge that might be undertaken. It's a long road between undertaking an application or an action and actually getting a successful verdict. And so right now we're in the exploratory stage of doing that. I think we have the resources we need to carry out such litigation. The main thing is to make sure that we have the right foundation for it. And that's what we're working on right now.
Thank you, Graham. And I'm not sure. Judith, did you have a question? Okay,
yes.
Go ahead, please.
For Jane, I've been told that the discharge planner in the hospital or the LIN, I still say LIN, it's easier than ACCSS. Okay,
we all do.
Yep.
Alphabet soup.
Really? Yeah. I've been told that the discharge planner or the LIN case manager might say, well, old lady, we'll move you into this less desirable place temporarily. And then when a bed comes available in your choice, we'll move you there. And I have my doubts. So would you like to comment on that?
Yeah. So yeah, I didn't cover that. There's so many things that are, parts of this puzzle. So the answer is yes, that the beds that the HCCS will choose for you are in addition to any beds that you already have on your waiting list, and that you will wait for the home on the waiting list from there. The problem is that even if you're a crisis move, and it's not really clear whether you'd be crisis only for your first choice, which is normally what happens, or for all of them, what have you. It's not exactly sure. It's not really clear on the designations, but just even assume that you're crisis for all of the beds in the homes that you're waiting for. Again, you're competing against the hospital folk, who they're still going to get preference over you, because that's the whole point of this legislation, is to get people out.
I'm already in the hospital.
No, but you move if you move into your home, you move into shady acres that you didn't want to move to, and you really want to live in Happy Valley, you can be crisis in shady acres, but the hospital patient is always going to get that bed available because they are seen as more like they're seen as a higher crisis because because they need it, because the system needs it. And then the odd person in the community, you know, where maybe their caregiver dies or their house burns down, they might get in. But this is the problem, is that we've now funneled all of everybody into the hospital. And you're right. And that's, I mean, we have tons of people who've been in the community on crisis for years, and they can't move anywhere because only hospital patients are moving on the crisis list. So they have to deteriorate to such a point to get in the hospital to even get out.
Got it. Thank you.
Now, I'm aware that Jane has another obligation this evening. I don't know whether she's able to stay any longer, or whether you...
I can stay for a couple minutes, if anybody has another question.
Jane, we had one more question here that was sent through the chat, and they were just wondering, how many homes may you choose or have to choose if you are in the hospital?
So there is no number in hospital. The maximum number, if you are in the general sort of application process, is 5. And when you're in hospital, you're on crisis. So that is actually lifted. You can choose as many as you want. Generally, hospitals will usually tell you have to choose 5. It's not mandatory, but we're now in a system where they're also looking at, are you being reasonable? So I would certainly tell people, it's so individualized, you know, it's really hard. Like if you live in like Kenora, if they only have 1 home or 2 homes, I mean, that's probably all you're going to choose, right? So I think that people, the more you can choose, you got to remember, the more you can choose of the homes that that's acceptable to you. They may not be perfect, but the more that you can that are acceptable to you, the less likely you're going to end up in a situation with the crisis. So if you only pick Yeehong that has an 11-year waiting list and you refuse to put anything else, that's when they're definitely going to come and say, you can't wait for here for 11 years for Yeehong. But if you've chosen, you know, 2 or 3 that have a longer list, but then chose a couple maybe that are in your local neighborhood, so at least you could go and visit all the time, which I actually think is often one of the most important things. Of course, with COVID, since you couldn't visit, that sort of fell apart. But, you know, I think that, you know, some of that there are other things to be looking at than just, you know, the best and brightest and of the facilities. And if you're looking for, you know, if you're saying, well, that home speaks Lithuanian, well, that's nice, but the people in the hospital don't. So it's not actually a really good argument to say I have to wait in the hospital for a Lithuanian home, because you're not getting Lithuanian care in the hospital. So you could wait in another home for your Lithuanian home. And, you know, so making choices as to like, how do you manage that so that you can get in somewhere that's going to be of your choice, and it's going to be better than because we know what kind of homes that is going to be on those lists. We know that the homes that people are being told to go to are Orchard Villa and places that had the military in there that had terrible records. I'm actually going to have to go because unfortunately I have to go speak at Osgood now. So I want to thank everybody for today. And I don't know, maybe if there's anyone with any other questions, maybe somebody else could answer them, because there's certainly other people here.
Yeah, I'll step in here.
Graham might be able to answer. And thank you very much for having me. If you haven't read the article that I wrote, please read that article. It's a lot more about what I just talked
right
to.
Here.
Thanks very much.
We had previously held a much more consultative relationship with government. Increasingly under the current government, we are finding it harder and harder to get through the walls to government. They are consulting with us and other stakeholders less, to the point that we see Bill 7 go through without really any substantial public consultation at all. The government did hold up a mirror and speak to groups they knew would agree with their position. And beyond that, they have not consulted widely. So I don't think we need to feel slighted. I think that we're in the vast majority of stakeholders who are not being listened to, and we need collectively to find a voice.
Thank you again, everyone. And thank you for being so attentive when Jane was talking, which is pretty easy to do because she's a very compelling speaker. So hopefully we will see you again soon. And thank you and take care, everyone.